Well, good afternoon and welcome to another Zoom seminar in the King's Chamber's Costs series. This afternoon, we're going to be looking at the vexed and vexing question of wasted costs, which is, in my experience, and I think Paul's too, one of the more fraught areas of cost litigation. So to give you a few pointers about how we're going to deal with this, we'll go back and forth in a talking heads fashion about the various topics we want to explain to you. We'd like you to give us questions too, using the questions facility or the chat, and we'll pick those up as we go along and work a response insofar as we can. And we'll take about an hour to go through a number of topics. So what we're going to look at is wasted costs, what it is, the jurisdiction that the court has to make a wasted costs order, some of the key requirements or criteria for making an order, which will include the conduct, causation and justice test, some points about procedure, the vexed question of privilege, give you some examples where a court will and won't make a wasted costs order, and also look at the parallel jurisdiction under Rule 44.11, which covers some of the same ground as the wasted costs jurisdiction, but also has some important differences. So when we think about the context of wasted costs, this is a jurisdiction that's been around for an awful long time. And it's probably a jurisdiction which has its origins in the court's inherent jurisdiction, though now it's firmly grounded on a statutory basis, as we'll look at in a few moments. But where are the circumstances or the case context in which a party might apply for wasted costs against the legal representatives of the opposing party? Well, an obvious example would be where there is questions of solvency or insolvency of the opposing party. And in those circumstances, the solicitor and their professional indemnity insurers can present a tempting picture of a somewhat deeper pocket. Quox cases in the personal injury sphere, where there may be no effective remedy against a claimant who has the benefit of Quox protection, and indeed may also be impecunious, but again, there may be the prospect of some recovery against their representatives. And also, it has to be said, where there is something of a conflict between the lawyers representing the parties. And time again, I've seen over the last 25 years that where there's a breakdown in relations between the solicitors on record, that is often fertile ground for the seeds of wasted costs to be sown. Wasted costs can involve the payment from a legal representative to the opposing party, but it can also involve an application by a client for a disallowance of costs that they might have to pay their own solicitor. And wasted costs count not only in terms of the financial damage that an order can represent, but because if a solicitor has a wasted costs order made against them, then they have to inform, and indeed the court will inform, their regulator. And of course, it can have consequences when it comes to renewing professional indemnity insurance, as often disclosure will have to be made of a wasted costs order made in that year. So with those broad considerations in mind, Paul, can you take over the baton and tell us a bit more about wasted costs?
Sure, thanks, Andrew. Well, as Andrew mentioned a minute ago, the origin of wasted costs is in the court's supervisory jurisdiction of the officers of the court, but it's been given statutory force by Section 51(6) and 7 of the Senior Courts Act 1981. Subparagraph 6 of that Act provides, as Andrew said, for the ability of the court, jurisdiction of the court, to disallow or order a legal representative to meet the whole or part of any wasted costs, and those are to be determined in accordance with the rules of court, which we now know obviously is the procedure rules. Wasted costs are defined in statute in subsection 7 as costs incurred as a result of improper, unreasonable or negligent acts or omissions on the part of a legal representative. So it's not just acts, but it's a failure to act, a distinction sometimes forgotten. The procedure is set out at CPR 46.8, so these are the rules of court to which the Senior Courts Act refer. And as with any judicial or justiciable process, it is required that the legal representative has the opportunity to make submissions or attend the hearing at which the order would be made. Now, we'll come on to the procedure for the order to obtain an order in due course, but we'll get the bones of the jurisdiction and the test set out here. What is a legal representative? Well, a legal representative, the definition of the Act, is essentially a party has the right of order, who has a right of audience and the right to conduct litigation. Usually, that party or the legal representative will be the opposing legal representative. It'll be alleged that that legal representative has done something wrong or failed to do something that they ought to have done that meets the test that's applied. But it's a broad approach to the courts tend to take a broad approach to the definition of legal representative, but it doesn't actually have to be a legal representative that is on record. It could be a legal representative that is supervising or assisting the party that is bringing the proceedings. And so, whilst it's a broad definition, it needs to be a legal representative who has the right to conduct litigation or a right of audience. And of course, there's no objection to an application for a party. A party could make an application for a wasted costs order against their own legal representative, although it's usually the opposing legal representative. There's a requirement that some proceedings have been issued in order for the jurisdiction to be triggered, but that doesn't mean that acts or omissions which predate the issue of proceedings and which satisfy the test cannot be pleaded in support of an application for wasted costs. The only requirement is that proceedings are then subsequently issued. So it's not acts in proceedings, but it's proceedings which are issued and acts within the context of the entire claim. The requirements of any application there is effectively a three-stage test that is now set out in 46 Registration 5.5, but that reflects the common law as set out in Rydalshire Horsfield, a case which I'm sure you will all have heard of, 1994, Chancery 205. And that's a three-stage test. The key point to remember in wasted cost applications is that it is not simply has the legal representative acted improperly, unreasonably, or negligently, and then I get my costs. There is a three-stage test, and the application can fail at any one of those stages. Of course, first is the breach requirement. Has the legal representative of whom complaint has been made acted improperly, unreasonably, or negligently? Come on to those tests in a minute and the overlapping nature of them. Secondly, though, if a breach can be established, this is the causation requirement. Did the conduct cause the applicant to incur unnecessary costs? And so this is a crucial part of the application, and it's one that's very often, in my experience, ignored. It can be a real banana skin on any application, because whilst a breach early on in the proceedings, which fundamentally undermines the claim, for example, a failure to disclose a crucial document at a very early stage that changes a party's mind once it has been disclosed, might cause costs. Acts later on in the litigation, which cause only modest costs, will be treated differently for the purposes of causation. So they might not affect any cost leading up to that point. So the point about causation is one to remember. That's the second point. So we have the breach requirement, the causation requirement, and then the justice requirement. Even if you can establish that there's a breach and that there is a causative cost or cost causatively incurred. The third requirement is that it is just in all the circumstances. Test you'll heard from the judiciary before, in order for just in all the circumstances for the legal representative to pay wasted costs. So that's the three-stage test. Now, the three breach requirements overlap, and they're considered extensively in Rydalshire. Improper generally means that conduct which according to the consensus of professional opinion could fairly be stigmatized as improper conduct. Unreasonable and negligent, there's certainly an overlap between the two. unreasonable conduct generally is said within Rideout, includes vexatious conduct which is vexatious or designed to harass the other side. But in reality, this is generally taken as being satisfied, the test is generally applied is whether the conduct permits of a reasonable explanation, not just an explanation. Negligence is what we would understand negligence to mean, failing to act with the competency expected of a reasonable and ordinary member of the profession. But a bare finding of negligence is insufficient. The concept of wasted costs involves a breach of the duty to the court, or a breach of the duty that the legal representative owes to the court. So mere negligence is insufficient. Now, generally, improper conduct is viewed as the most egregious of the three, but of course any of those will satisfy the test. So what sort of conduct would satisfy the test? Well, and particularly with regards to a breach of the duty to the court, abusing the process of the court, or abuse of process in the sense that we would generally understand it, would be sufficient. But so, for example, using the court process to obtain something other than success, just as effectively to perhaps to deprive an opposing party of money, or to obtain a remedy that is unnecessary, or litigating effectively for reasons other than a proper reason to utilize the court process, would be an abusive process, and that would be sufficient to be a breach of duty to the court. One area that does merit mention, that will very often not be sufficient to merit a wasted costs order being made, is the concept of a hopeless case. Now, this is, of all the wasted costs cases that go across my desk, the hopeless case application is probably the most frequent, particularly when in circumstances in which the entire costs of the litigation are being sought. And that's because there's a real temptation when proceedings come to a conclusion, either by discontinuance at a late stage by the party bringing the proceedings, or even in a case in which a damning but not a judgment that's damning but not sufficient to cause a claimant to lose the protection of quox is given. The real temptation is to seek the costs from the unsuccessful party. And now this was an argument that was recognised in a case called Dempsey and Johnston, 2003. We'll be providing some sheets after this seminar, so you'll be able to see the cases to which we're referring. This was recognised and as a temptation that those who are successful in defending litigation suggest that legal advisors who pursued or defended that litigation should not have lent their assistance, or shouldn't have kept it going for as long as they did. The key principle, again, is set out in Rideout, and there's no justification for a wasted costs order merely because a solicitor who acts for a party pursues or assists the party in pursuing a claim that is, I open quotes, blatantly doomed to fail. And that's because the courts prioritise access to justice within fairly broad limits. In Dempsey, Lord Justice Latham made the point that even if a client insists on giving evidence which the legal representative considers may well have no chance of being accepted, it's not, the legal representative is not the judge, and the client is entitled to have his case on the facts determined by a court. So it's not for a legal representative to take a view on the facts and whether or not they're likely to be accepted. It is for the judge. If a client wishes to run a case which is likely, if not extremely likely, if not plainly doomed to fail on the facts, then the client's entitled to do that, because that's what we offer in this country, the access to justice. The only question, the limit to that proviso is, well, the limit to that principle is where no reasonably competent legal representative would have continued the action. But it's very difficult, Lord Justice Latham said, to see how no reasonably competent legal representative would have continued the action if it wasn't also an abusive process. So effectively, the bar is set as high as abusive process in hopeless cases. And so that makes sense because there's no obligation, although a solicitor might be able to terminate a retainer because the case prospects reduced below 51%. There's no obligation to do that. A claimant solicitors solicitors owe no duty to the other side. They owe no duty to streamline allegations, to limit those to those which are most likely to be accepted. The client's entitled to bring the full case, the good and the bad. And it's for the court to determine what is the good and what is the bad, if at all. Now, in King and Stiefel, a case which I recommend reading for a very helpful summary, it's in 2023, and paragraphs, it's the judgment of Mr. Justice Jacobs, and paragraphs 68 to 96 set out the applicable principles for wasted costs applications, and recently, last year. But very useful sort of summary of all of those points, sort of points that we're going to be running over today. And Mr. Justice Jacobs said that in the context of pleadings, where there's a weak but a factually pleadable claim, the barrister, or for that read also legal representative, should indeed plead it and could be criticised if there was a decline to do so. So where there's a weak but pleadable claim, Lord Justice Led said we're not even in the realms of wasted costs at all. Now, as far as on that point, as far as if it were a barrister that was to plead it, solicitors can't simply shelter behind counsel by saying, well, as counsel's name, we're pleading. We relied upon counsel for the pleading, and therefore we're not in breach. If anybody's in breach, it's counsel. That is not an argument that we'll accept in very peculiar circumstances where there is a particular specialism upon which the solicitors rely, and one in which they could be expected to have a reasonable degree of knowledge. And that argument won't hold water, because the solicitors have to apply their own professional mind to the advice received, and they owe their own duty to the court. And so it's incumbent on solicitors to consider counsel's advice. And it's very rare that solicitors will simply be able to shelter behind counsel and avoid a wasted cost order, because they also have a duty to the court. We will come on to deal with privilege shortly, but it is worth to just put a marker out that where you are running a hopeless case application and privilege is claimed by the respondent to the application, privilege is effectively claimed by if the claimant refuses to waive privilege, if the opposing claimant, usually the claimant, if the claimant refuses to waive privilege, and the solicitor says, look, I'd like to tell you everything about this case, but I can't because the client's refused to waive privilege. And the argument is that there's something in the papers that shows that this was a hopeless case. The court have been clear to effectively say that it will be a very exceptional case indeed, in which a court will be entitled to infer that a party is abusing the process of the court by pursuing a hopeless case. And that was by reference to Rydart for this case called Ratcliffe, Dewson, Gamma and Binns and Mr. Justice Elias. And so those cases will be hopeless cases in which there is no waiver of privilege, and so you won't be able to look at the file and see exactly what was said or what wasn't. Those cases will be extremely difficult to run. So in summary, to limb 1 of 3, the breach requirement, that improper, unreasonable or negligent conduct in such a way as to breach duty to the court that's caused, and then we go on to limb 2, which is causation. I'll hand the baton back to Andrew to deal with that point.
Thanks, Paul. Before I launch upon causation, we've had our first question, which is asking for the distinction between a hopeless case and what is a frivolous or meritless case. And I think one of the ways to explain it would be to look at some examples. So in a case that I had within the last year, there was an allegation of layering, in the sense that the injured claimant in a road traffic accident maintained that he was suffering from tinnitus in one of his ears as a result of the accident. The only difficulty for the claimant was that he couldn't decide which ear it was that he had the tinnitus in. So he told his solicitor, seemingly that it was one ear in the letter of claim. He told the doctor that it was the other ear when he went to see the doctor. In his witness statement, he reverted to the first ear that he had chosen. And not surprisingly, when confronted with this litany of inconsistencies, the case crashed and burned at trial. And of course, in those circumstances, what the successful defendant did was apply for wasted costs. But the application failed. And the reason it failed was that although the case might have been hopeless, I think the position must be that if a client who is confused or has language difficulties or something of that nature was to actually settle on a definitive series of events, it's not the job of the solicitor at that stage to necessarily judge their client. It can also be very difficult to do so in circumstances where, of course, the solicitor owes duties to the client. Layering over this, of course, is the question of privilege, because there may be any number of reasons as to the inconsistencies, but the solicitor's hands may be tied. And so that may be an example of a hopeless case. Suppose, however, that there was correspondence in that case where the solicitor had written and said, we've got this claim, even if you think it's a bad claim, it's going to cost you 10,000 quid to defend it. So why don't you make an economic settlement to our client now before we issue proceedings? That sort of letter can, of course, lead to an inference being drawn that the Quox rules are being used to leverage a settlement, almost in a form of blackmail. And in those circumstances, you might be getting into the foothills of an argument of abuse, that you are abusing the Quox protection that your client has in order to bring a meritless claim, and the defendant therefore has a foot in the door for a wasted costs application. So that is how I would distinguish hopeless from abusive. And as I say, and as Paul has said very clearly, hopeless cases aren't enough. Where it becomes abusive, that is when the door starts to open. That, I think, is the point I wanted to make on the question. Were there any points you would add to the question which Maria put forward, Paul?
I think just one, Andrew, and that is that there is a distinction to be drawn, Maria, between hopeless cases which are hopeless on the facts and at the court being the appropriate tribunal to determine what the facts are, and cases which are hopeless on the law. And so cases which are issued in ignorance of a binding legal principle that would be apparent to any reasonable member of the profession, those cases are unlikely to be affected by privilege or considerations of privilege, because if a client says, I want to sue for X on the grounds of Y, and the Y grounds are effectively do not constitute any cause of action in English law, then the solicitor does have a duty to the court not to bring proceedings which are, it seems to me, that not to bring proceedings which in which there is either a binding legal principle or no legal principle at all, unless, of course, it's just trying to create new law. But if it's something as simple as a botched pleading with no real cause of action, then that seems to me to be different to something which requires the adjudication of the court on the facts.
So on to causation, which is the second of the three tests. The first test being conduct. Causation I'm going to talk about now, and then the third one, justice, which we'll have something to say about in due course. Now, causation is an extremely important issue, and often it defeats an application for wasted costs in its tracks, because the onus and the burden is on the applicant all the way through to show causation, to show that the conduct which constituted a breach of duty to the court has actually caused the incurrence of costs that would otherwise have been avoided. And I think for at least 30 years, that has been regarded as a test of but-for causation, which is a particularly high requirement to prove on the part of any litigant, but particularly in this context. there may be scope to argue that it is in fact effective causation on the authorities, which would promote a wider test of causation. But I would say that 9 judges out of 10 are going to treat it as a question of but-for causation. And what that means, drilling down, is that you have to be able to show, or to argue that your opponent can't show, that particular costs were incurred by particular conduct. And there is a requirement to prove those costs, which is often done by way of production of a schedule of costs, which can identify particular elements of costs which have been increased to the extent that they would otherwise not have been done. Vague allegations won't do. So if you're going to say, well, this and this happened and this happened, and therefore probably the case would have gone to the fast track rather than the multi-track, and we've incurred more costs than we would otherwise do, that's not enough. On the other hand, if you could show discrete elements of costs clearly identified, such as the costs of an adjournment, which have been caused through, for example, a solicitor failing to notify the witnesses as to the trial date, then causation is going to be nailed on, because clearly there is a duty on the part of the solicitor to get the witnesses to court. If the solicitor has not done so, then you're into conduct territory. The failure has caused the adjournment of the trial, and the costs of the trial are a discrete part of the case, the cost of the adjournment, which can be quantified with a degree of precision. And so that is the sort of tightness that you want when making a case or resisting a case in terms of causation. In particular terms, there are a number of authorities which emphasize the requirements of causation. I think one that Paul and I both like is the case of Nwoko and Oyo, decision of Mr. Justice Eder, where the judge effectively threw his rattle out of the pram by saying it is unacceptable for any party simply to throw at the court a schedule containing a large bunch of figures, which the court is then expected to plough through in order to arrive at some principled decision. And unsurprisingly, against that context, the judge found that the evidence on causation just wasn't there. I should say, and I think Paul has already mentioned, that when we refer to cases, we are going to send out a set of notes which have all the references in them so that you can look at them in a little bit more detail. But I think that if one had to look at this in terms of your strategy and tactics, there are 3 really big issues in these sort of cases. The first is establishing conduct which is a breach of duty to the court, because that element can't be emphasized enough. The second is causation, and the third is privilege, which we're going to talk about in a little while. But back to you, Paul, to have a chat about procedure.
Yeah, I'll just talk a little bit about the procedure then. So a wasted costs order can be sought usually at any stage, obviously, when a costs order has been made. The application doesn't need to be made at the trial, but more often than not, they are. There is, I think, a bit of a haste on the part of solicitors in order to try to make these applications too quickly without getting the house in order at the end of trial, because they take the view that there's some sort of notice requirement, and if without a notice requirement, then the court will kick out a late wasted costs order. In fact, there's no authority for that at all. In fact, there's authority to suggest that solicitors should bring the application properly rather than prematurely. And so it's probably best to get your house in order to put a proper application before the court, rather than trying to rush it and deal with it ad hoc at the conclusion of the trial, rather than by way of formal application, for example, afterwards. Of course, it doesn't have to be done at trial. It can be done at any stage. The procedure will usually, a wasted costs order, be done in 2 stages. The first is the show cause stage, and that is generally determined by reference to evidence which, if stage 1 will be passed, if a solicitor or if a party satisfies the court that there is evidence which, if unanswered, is likely to lead to a wasted costs order. So that's if you like, the prima facie case. And stage one applications, in my experience, can sometimes involve far too much documentation. It should be a summary. The whole process should be a summary procedure, but the courts are willing to dismiss cases at stage one if the costs of going to stage two, which is which is where the court decides whether to make a wasted costs order, which is justified to make a wasted costs order, which is justified in view of the likely costs involved. The decision as to whether or not to go to stage two will be taken in light of the likely costs that are involved in running it. And generally there should be at stage one, certainly, no detailed investigation into the facts. Even at stage two, there shouldn't be any disproportionate time or cost involved in making a wasted costs order. The courts have said time and again, and it's repeated also in King, that this is a summary jurisdiction that's to be determined in that way. And considerations of proportionality can cause cases to be dismissed at stage one. In a case called Kagalovsky, Mr. Justice Turner dismissed the case at stage one because there were 9 lever arch files of documentation. The costs were already 70,000, were expected to go to 110,000 for stage two for a 2-day, include a further 110 for a 2-day stage two case. And Mr. Justice says it was simply not appropriate case for wasted costs. And Rideout also makes clear that the costs, the wasted costs application shouldn't go forward if it cannot be dealt with in a summary manner at proportionate cost. And if the court does take the view that the stage one of the test, the prima facie test, has been satisfied, generally there will be no formal order for disclosure. There'll usually be a witness statement, obviously, in support of stage one, and a witness statement in rebuttal. It would be unusual, but it does happen, if there is a further witness statement at stage two from the applicant, but the applicant should have made its case, and it's for the respondent to answer it. Of course, the applicant has the burden of proof, as Andrew's mentioned. As for oral evidence, well, it is only in exceptional cases that cross-examination of the legal representative would be ordered. Generally, the case should be, in the spirit of being dealt with summarily, dealt with on the basis of witness evidence, and generally within 1 day. The courts have said that wasted costs applications, stage one or stage two, should be capable of being dealt with in hours and not days. So you shouldn't really be looking for a multi-day stage two hearing. And if you make that application and you anticipate it, then expect it to be given short shrift by the court, because it's unlikely to be a summary. Of course, in any application, there'll be considerations of privilege. I'll just pass back to Andrew to say a few words about that before we move on.
Yeah. It's just picking up at some points on procedure. In any form of litigation, it's very tempting to layer your case with layer after layer of allegations, documents, evidence, and so on. But in the wasted cost jurisdiction, that can be counterproductive, because you have this principle, Kagalovsky being one such case, that it's a summary procedure, and the more involved, the more complicated, the more time it will take to resolve, the less and less it appears to be a summary case. In those circumstances, there's a real risk that the case will be kicked out at stage one. Whatever its ultimate merits, it's just not proportionate or appropriate to pursue it. The other 2 points that Paul makes, I think, are really very important indeed. There is a tendency, again, to try and get hold of disclosure in many circumstances, because, of course, you may not trust what your opponent is saying. You may wish to have the benefit of contemporaneous documents. That creates problems with privilege, as we'll see in a minute, but it also, of course, is taking the nature of the application away from a summary procedure and turning it into something more like a contested action. And again, if you say you need disclosure to deal with the case fairly, that is going to be counterproductive. And the final point about cross-examination being inappropriate, that really hinges upon the difficulties that privilege might create for a particular solicitor who may have given such evidence as he or she can, but can't really go further than their witness statement. And in those circumstances, most judges will decline to order that the solicitor attend for cross-examination. Conversely, if you are applying for wasted costs, you very much want the solicitor on the other side who's given a witness statement to attend for the purposes of cross-examination, because you may very well wish to probe the detail of what they're saying. And so that is something which needs to be considered. But again, it raises the prospect of the case being refused at stage one, because once you get into a contested hearing, solicitors giving evidence on oath, can you really describe it as a summary procedure? So Paul and I have mentioned privilege on a number of occasions, and I think that it's a good opportunity to sort of recap on what privilege is and what its importance is for these particular applications. Legal professional privilege is not the lawyer's, it's the client's privilege. It's the client's privilege going back a very long time now in legal history, and it enables the client to make a full clean breast of their case to their client, with the knowledge that it will not go further than the solicitor that they instruct or counsel they instruct. And it also is something which is not subject to being displaced by the normal rules of disclosure or Part 18 requests or anything of that nature. So when a application for wasted costs is made against the lawyer may very well wish to give a complete account of the facts, but the lawyer's client may say, no, this is my information, my confidence, my privilege. I do not want you to disclose this. And if the client takes that position, there's nothing that the lawyer can do about it. But that could lead to an unfairness in that the lawyer will effectively be defending the application with one hand tied behind their back. And so the authorities have developed to deal with this on a practical basis. The original formulation in Rideout says that where there's a doubt, the benefit of the doubt is given to the lawyer whose hands are constrained by legal privilege. Only 8 years later, in the case of Metcalfe and Mardell, that guidance was strengthened so that the point was taken effectively that unless the court is so sure that this is a clear-cut case where there's nothing the lawyer could do which would stand in their defence, then only then can the court properly make a wasted costs order, and otherwise it should dismiss the application. Now, the practical consequence for that is that in many of these cases, a lawyer who's being made the subject of the application will actually, in practical terms, possibly be better off if their client maintains their privilege. Because in those circumstances, the court is deprived of a key part of the evidence, and the authorities are dictating, prescribing, directing the court to dismiss the application because of the fairness of the argument. So those are my initial thoughts about privilege, but what would you add, Paul?
Well, firstly, I think I'll just deal, before I forget, with Julia's question, which is, am I correct to assume that a wasted costs order against an opponent's solicitor could only be solved if there is a costs order against the actual opponent? Well, that's not right. You don't need an order against the actual opponent in order to seek a wasted costs order. There's no difference between, I was probably a bit unclear on this when I made the point earlier on. There's no difference between making an order for costs against the opponent in the sense of the parting, which will usually be the precursor to a wasted costs order, but it doesn't have to be. And the order against the legal representatives, they're all part of the same process, which is the court allocating costs at the conclusion of the case. Of course, with a wasted costs order, there are additional hurdles, whereas you're probably going to get a wasted costs order against the claimant if they lose, because the general rule is, of course, that the unsuccessful party pays the cost of the successful party. So that's a very low hurdle, whereas wasted costs order jurisdiction's a bit more of a high jump. But no, you don't need a pre-existing costs order, but usually will have one in order to seek a part of those costs from the legal representative. The second point, the point that follows on from what Andrew has just said, is an important one. In cases in which privilege has been, in cases in which privilege is likely to be an issue, then the court will, as Andrew has referred to, give the all allowance principle. So the court must give the respondent to the application, if privilege is not waived, a full allowance for the inability to tell the whole story. And as made clear in Metcalfe and Mardell, the court would have to be very slow to consider that there was no sufficient, that the practitioner could have no sufficient material to resist an order. The court said in Metcalfe, speculation is one thing, the drawing of inferences sufficiently strong to support others, potentially very damaging to the practitioner concerned, is another. And that, of course, will be a fairly exceptional case in which the court can draw inferences for the exacting conditions, so that there is no room for doubt that whenever the respondent said a wasted costs order would be appropriate. All the respondent has to do is effectively raise a doubt in the mind of the court, and the court will have to give the lawyer the benefit of the doubt. When making any application for a wasted costs order, it is imperative to consider whether privilege is likely to play a part, and if so, what part it will play. And that will be largely influenced by the nature of the application. So if, for example, and I'll come back to what I said earlier on about a substantive error of law by the solicitors. If it's a substantive error of law by the solicitors, it may well be that whatever the client said, the solicitors are on the hook for a wasted costs order. And so the absence of waiver of privilege doesn't make as much of a difference. If it's a clear and obvious procedural error by the solicitors, that also may mean that privilege is less relevant, although query whether or not the claimant could have influenced the procedural failure by failing to respond. The solicitors would be entitled to the benefit of the doubt if they wanted to say that. If it's a hopeless case on the facts, that's very different. Privilege is very likely to be, the absence of waiver of privilege is very likely to be relevant, because I'm sure the solicitors would want to say a lot about what the client had told them, what the advice they'd given. Same with regards to dishonesty or the allegation of dishonesty. Very difficult to run a case on hopeless case or on dishonesty absent a specific finding. Of course, if you had to have the specific finding, then quox privilege applied, you'd be entitled to enforce. But if, let's say, you still took the view that the client was unlikely to have the means, wasn't funded, certainly wouldn't be ATE backed for that, and didn't otherwise have money to satisfy any costs order, the question as to whether or not solicitors had been effectively colluded with the client who wants to bring that claim, or had sufficient knowledge to bring that claim and bring that as a breach of the duty to the court, would be very difficult to run absent any particular judicial finding, and certainly in cases in which cases look like they've been discontinued because they were obviously dishonest. There's no they apparently appear to be obviously dishonest. Those cases are not the kind of types of case in which it is easy to run a successful wasted costs application absent there being a waiver of privilege. So it's uncommon in my experience. It's certainly the exception rather than the rule for privilege to be waived. And it's more likely in circumstances in which the claimant blames their solicitors for not doing a good enough job. But how do you obtain the access to the file? Well, I suppose as an applicant, you could write to the claimant if they're no longer a client of the solicitor. Write to the claimant and invite them to indicate that an application is being pursued and that request whether or not they wish to waive privilege in relation to the file. That certainly happened in cases in which I have acted, and clients have either chosen to waive or not privilege. But my experience is generally that privilege is not waived. Alternatively, you can ask the solicitors to confirm that they've asked the client to waive privilege, and you can rely upon what they say in response. There's not really a great deal you can do if they respond and say that the client has not waived privilege or the client is not contactable, because if privilege remains not waived, there's no jurisdiction for the court to draw inferences from anything that's done or not done by the solicitors in order to obtain that waiver, because the law is as it is. Andrew, I don't know whether in relation to that you've got anything to add before we deal with quantum, but those are my experience. In practice, my experience is that privilege is not very rare. It's very rarely waived, and B, there are only certain steps that you can take to see if you're an applicant to see that it is, because obviously access to the file is the ideal, but it's not easy to get.
Yeah, I think it sort of raises 3 points or 3 ways that I would address it. The first is, I think you're right, Paul, there's a hierarchy of cases here where at the top, the easiest ones to get an order in these applications is where there's something that's clear-cut. A solicitor acting without authority from a client, a procedural default, something of that nature. And then at the bottom of the hierarchy, the cases that are the most difficult, and probably the cases that you should think extremely carefully about taking at all, are the ones where there could be issues about privilege, or there could be issues about the hopeless case point. The further point, I think, that flows from this is that in terms of what is your strategy in relation to this, my inclination would be to say, well, you've got to look further down the road and think, is privilege going to play a significant part in this or not? And if privilege is going to play a significant part, then do you actually say, well, actually, we're not going to go any further because of the difficulties that you've outlined? The further point, I think, that flows from all of this is that, yes, you can hope that the client who has fallen out with the solicitor will waive privilege, but that in itself can't be counted on. That in itself may not be conclusive. And that, of course, it simply illustrates that may be a subsidiary, less than satisfactory strategy, again, raising the question as to whether you proceed at all. We've had a couple of questions, Paul, which Lucy has asked, what impact does fixed recoverable costs have? The answer to that is probably none, because most of these applications are for indemnity costs on the basis that they are steps out of the norm, unreasonable or improper or negligent conduct. Therefore, the measure of cost should be the indemnity cost. But in any event, there would be a question as to fixed recoverable costs only applying between claimant and defendant. I don't see why they would impact on non-party costs. I don't see why they should impact on wasted costs. And the other point which was raised by Guy was the relationship between show cause and the but-for rule. Show cause is really a screening process. That's all it is. Is there something here which should go forward to a full determination? Always the causation principle applies, and it's the causation principle which is test 2 of the 3 tests that we've outlined. So, good God, Paul, we've already reached 16:49 on the clock, only 10 minutes left to go, and we've still got a bit of ground to cover. Do you want to say anything about the examples that we've thought about in relation to wasted costs?
Yeah, so I should say just briefly, there will be a slide in relation to the quantum of wasted costs, and 30 seconds on this, usual principles apply with regards to quantifying wasted costs, subject, of course, to that quantification being within the scope of causation that is established at that stage at the second limb of the test. So you've caused wasted costs, and those costs are still to be assessed on a standard basis. And the usual principles apply, but it is open to a court to argue. It's open to a court to order that wasted costs should be assessed on the indemnity basis as being costs which are out of the norm. The case that you'll see referred to is Rayner Hughes and LV Insurance, in which indemnity basis costs are ordered against solicitors for defending the indefensible. On the flip side, the applications which are premised upon improper conduct and dishonesty, if they are unsuccessful, then in similar to sort of failed fraud cases, it's open to a court to order that the cost of the application should be assessed on the indemnity basis. Now, on to the examples. Well, what sort of things then justify a wasted costs order? Well, I've referred to a couple during the course of our discussion, cases which are fundamentally flawed on the law, cases in which, because you're reduced to the court, there's been a failure to liaise with the court and a failure to liaise with your own experts, then perhaps a failure to properly instruct your own experts to deal with the issues at hand, which causes them to, for some reason, to provide an opinion which is either not CPR Part 35 compliant or not properly aimed at the case itself. On the other side of that, if your case simply fails because one expert has outgunned another, that's not a reason to support a wasted costs order. That is just litigation, and unless there is something that you have done wrong in order to cause that imbalance, then there'll be no success of a wasted costs order perspective. Another one that I've seen is, and it's quite a common one actually, a failure to disclose a document which the applying party says would have made a difference. So, but for the failure to disclose, we would have conceded the claim. But because the document was disclosed at a later stage, we weren't afforded the opportunity to concede the claim at an earlier stage, and has as a consequence incurred X amount of cost. Usually that will be also a breach of a court order and probably be the subject of a sanction beforehand. But that is another potential problem. One more I'll refer to before I go back to Andrew. He might be able to refer to a couple more. Is where a solicitor obviously advances incorrect evidence. So there's an authority in which a solicitor signed an affidavit confirming that a company was insolvent when it wasn't. Things like that. Evidence which is incorrect and fundamentally, factually incorrect, not just legally incorrect, but factually incorrect. That sort of conduct is, of course, a breach of the duties of the court. So those are some examples of where you might find some ground for a wasted costs order.
Yeah. Yeah, and just to add a couple of those in my recent experience, solicitors acting without authority. Maybe they're taking instructions from a director of a company and bring proceedings in the company's name, but the director doesn't have authority to bind the company forward. Or maybe it's an action on behalf of an estate, but no grant of probate, no letters of administration have been obtained, and the action is the nullity and liable to be struck out. Those sort of stark mistakes, if you like, will usually warrant the wasted cost jurisdiction being applied. I think we're down to 5 minutes, Paul. Shall we touch briefly on 44.11?
Sure. Do you want to do that, Andrew, or me?
I'll do it, Paul. I'll do it. 44.11. Have a look at it, because this is in the rules. It's different to wasted costs because it applies to parties as well as their legal representatives. But it provides another string to the bow if you're wanting to attack someone for their conduct, because it imports the sanctions of costs for misconduct. Examples of sanctions can be disallowing someone's costs or ordering they pay you your costs, matters of that nature. And the significance of it, and the two key distinctions, are you don't have to show causation in this jurisdiction. It's a conduct-based sanction. But secondly, and also, the scope of conduct is narrower. It has to be improper or unreasonable. Negligent mistakes are not enough to make an order under 44.11. So it's a useful alternative. It also has a wider application than wasted costs, because it's the sort of a rule which can also be used to attack more generally litigation conduct rather than specifically failings by the legal representative. Paul, any thoughts?
Yeah, there was some, I think one of the points that is important here is obviously the distinction between 4411, although 4411 doesn't include negligence. There's a distinction between 4411, there's a jurisdiction in 4411 and the wasted cost jurisdiction, in that I don't know whether I can't recall whether you mentioned the absence of a need to prove any causation, but some of the examples that we'll be familiar with in relation to this jurisdiction, which is not compensatory but punitive in the sense that it's a way for a court to mark its displeasure at the type of conduct that's taken place. Generally, this is dealt with by reference to in my experience, generally it's dealt with in the context of detailed assessment proceedings. There's no reason why it can't deal with conduct in substantive proceedings, but the conduct in substantive proceedings generally is dealt with in the wasted cost jurisdiction. Some examples of when this is used, or when the jurisdiction is invoked, are for those of you that are cost lawyers in the audience, you will no doubt have referred to this if there are doubts about certification of a bill, hourly rates being claimed that are in breach of the indemnity principle. But bear in mind, of course, that negligence in and of itself is not enough. Mistakes, errors of judgment are not enough. Obstructive behaviour, again, failure to disclose appropriate information or withholding information. And of course, dishonesty. Those are, in my experience, the sorts of times that this jurisdiction is invoked. I rarely see it invoked in relation to the conduct in the context of substantive proceeding, Andrew, but you may have a different experience.
Yeah, I think you're right, Paul. And I think when I think back to case examples, it's, for example, where a conditional fee agreement has been forged, or at least the signature on it has been forged, or you have claims for what are termed estimated time, which are in fact made up time, and don't have any grounding in the reality of how the litigation was done. And it's that sort of behaviour which often comes to light on detailed assessment, because that's when the file is produced to the judge, that I think you can often see the misconduct laid bare. And typically, of course, in the mainstream litigation, people are getting on with the case rather than worrying about the costs at that until the end when you're into the assessment process. So I think that brings us up to 3:59. Any final thoughts, Paul, before we say goodbye to everyone?
Well, I think the key points to take away are don't forget about causation and the need to quantify what you say are the costs, because that's the biggest failure in any applications that I've seen. Failure to identify what costs it is said are caused as a result of the breach. And secondly, don't forget about the importance of privilege. You can get some way down the line in a wasted costs application, could have incurred a substantial amount of money, maybe some thousands of pounds, only to be met with client's not waived privilege. You don't know what we said to the client. We'd love to tell you, but we can't, and the court's not going to run with it. So those are the 2 points that I probably would take, other than the ones that people know, which is improper and reasonable negligence.
Those are good points, Paul. The only one I would add is within the helter-skelter of any of these applications, both sides need to step back and think and take a long, cool look at matters. Because if you're defending one, it's not just the money. The report to the regulator could be extremely unpleasant, as could be the renewal of professional indemnity insurance. And if you are making an application and it goes horribly wrong, then you could end up with egg on your face, or indeed something worse, if you've made lots of allegations which are found at the end of the day not to be proved. Yeah. So I think that brings us to 5 o'clock, and I think it's time to say goodbye to everyone. So nice to see you all again. We'll be back in the autumn.